Hello, everyone. Welcome back to the Divorce Depot podcast. We have had quite a hiatus with no episodes, quite some time, but I am back because I am now recording from the beautiful Gainesville podcast studio that my friend and colleague Nehemiah Harmon has started here in Gainesville. And with the magic of his technology, it is possible for me and for you, if you choose to have a podcast here too, to bring in guests from around the state, around the country, and around the world. And today, my guest is Mara Bernstein, who is an attorney in Boca Raton, Florida. So we are not in the same room, Mara and I. And maybe when Nehemiah is done with us, it'll look like we are, or maybe it will look like we're not. I don't know quite how this is going to turn out, because this is our first adventure into the revived Divorce Depot. So welcome back to the Divorce Depot. And today, Mara and I are going to talk about options that divorcing people have. Often when I meet someone, they do not even realize that there is a divorce option that goes beyond hiring two traditional attorneys. And I wish I had a nickel for every time I would meet someone and they would tell me, oh, if only I would have known that there's another option. And they talk about the destructive nature that their divorce had for them. And that says to me that they didn't have the right process. We could say that there's maybe 4 or 5 ways people can get divorced, and Mara and I are going to talk about them today. What's sad is when someone has the wrong process, when they don't select the process that will serve them and their family best. So, Mara, welcome to the Divorce Depot. You are our first guest for our new revived version of this podcast, and I'm so glad to have you here with me today.
Thank you so much for having me. It's my pleasure. As always, love being with you.
And Mary, your practice in Boca Raton is somewhat unique. Can you explain to us, our listeners, what it is that you actually do?
Yeah. So for many years, I practiced divorce litigation in New York City and then in South Florida. And there came a point in time where I just really started to see and hear that people really weren't happy. They weren't satisfied with the process and the results of their divorce. So I started thinking about divorcing different. That's the tagline. And providing my clients with alternatives to traditional divorce litigation. And the way we do it is we talk to our clients about what their goals and objectives are, who they are, who they're married to, who their children are, if they have any special needs, what are their financial circumstances. And we customize an approach that for that particular family that is more efficient, that is less expensive, that's more direct, streamlined, and less destructive to the family, because that is really the most important thing. Because even where people are getting divorced, there's still families, there's still connections, children. Even if your children are emancipated, there are weddings, there are babies being born, graduations. So
even the people with no children are often so much better served because they're able to go through the divorce process quicker so that they can move on with their lives, the next phase of their lives, faster. So we could say that one way for people to get divorced, which normally you or I would not be involved in, is they just go to the courthouse and buy a packet of forms, fill them out themselves, and file them. And that does work for some people, but I don't generally recommend that for anyone that has children or anyone that has a home, owns a home, or has other assets, because it's too easy to make a mistake. And I have seen mistakes. But that is an option, especially people with no children and none or very minimal assets.
Yeah, where there are no support obligations, it's a short-term marriage. So we talked about this before we were live on air. There's a continuum. So that we would call a pro se divorce. It means that you're not represented, you go to the courthouse. So the continuum is pro se, that's like the least intervention.
I would call it a do-it-yourself.
Or do it yourself. Yep. I'm a lawyer, so I'm using lawyer. But yes, and do it yourself. So the continuum is do it yourself to litigation. And what we were talking about before is everything in between that people don't even know about. There are so many alternatives.
Yesterday, a woman called me, and I have sent her to you. And this woman had hired already a traditional attorney, but she was very, very unhappy with the outcome. And she had already spent a lot of money and really had gone nowhere. So she went to court and had the attorney withdrew from her case. And now she has no attorney. Well, she thought her husband was also going to fire his attorney, but it turns out he did not. So now the court has ordered them to go to mediation, and I personally think it's a terrible idea for her to go to mediation as an unrepresented person if her husband is represented. And so that's why I sent her to you. So what can you do for somebody like that?
So I think it depends on where she was at in the litigation process, and what's happening in her case and how complex her case is. So, there are basic cases where people are W-2 employees where the issues are very, very straightforward. And if she came to me and the issues are very straightforward and, there wasn't a lot of acrimony involved in terms of different valuations of businesses or homes, then I would say that I could actually act as a consulting attorney for her. So what would that mean? I could, talk to her before the mediation and tell her what direction she could go in. Or I could appear on a limited basis, a limited appearance, and go with her to the mediation. That's something I could do. But if the case was much more complex, there were more sophisticated assets, alimony was at play, the child support number was not agreed upon, I would have to step back and really review the file.
But you could review the file and go to mediation with her.
Absolutely.
Does she have the ability to get the file from her previous attorney?
Yeah, the file is her property. And to tell you the truth, I mean, if it was in litigation, as a lawyer, I could get it from the docket. We could pull it from the docket.
Okay.
So all the discovery, the financial affidavits, and the pleadings, I could get that.
And now you also mentioned a case that you had recently and how this particular woman was really not going to be well served using the traditional attorney approach.
Right. So I had a consultation with a woman yesterday who came in with a stack of papers. And I said, "What is in that stack?" She said, "Spreadsheets that my husband is giving me, Excel schedules, proposals." And I said, "Have you been involved in the finances?" She said, "I know nothing. My husband is an investor. He has several side businesses and he wants to go to mediation." And I said, "Don't do that. Terrible idea. You can't go to mediation. Mediation is fabulous." And Elinor, you have trained thousands of mediators, people to you, as one of the great mediators in Florida and someone who's trained so many. But mediation is, I always say, it's meaningless if you're not a good candidate. And she was not a good candidate because you can't go into mediation without having the right information and the right education. So what I suggested to her was, she said that she went to a litigator who I know, and she said this guy was ready to blow everything up. She has 4 kids. She doesn't want to blow it up. I said, you might consider mediation, but before you consider mediation, You need to know what's in the pot, what your rights and obligations are, how this is valued, and you need to understand whether or not he's being transparent with you. So what I do very often is I work with a few very good forensic accountants, and they start the process. So I said, get in touch with this person, I'll connect you. That this forensic accountant will have a list of documents that he will require from your husband. If he gets all the documents, great. He'll do schedules, he'll do valuation, he'll evaluate what the income is for support purposes. And then you and I could talk about what the plan is, what the proposal is, and what would be right for you. If he doesn't provide it, then you know he's not being transparent, and mediation is definitely not the right process for you. You need to go to litigation because you need a court, a judge, to compel him to comply if he's failing to comply. So this is kind of like a teasing out process, and it's also an education process.
Definitely the person who is uninformed, we could say, or uneducated about their own finances is definitely not a candidate for attending mediation on their own. There needs to be research done first. The other candidate that's not really right for mediation on their own is someone that feels intimidated or coerced, either through domestic violence or otherwise, that they're just not comfortable negotiating with the person on the other side.
Yeah, I mean, very often a spouse, I'm not going to say a husband or wife, a spouse will say to the other spouse, we're going to mediate because if you go to court, you're going to get nothing. That's BS. It's just BS. That's an intimidation tactic. And, you know, there's physical abuse, but there's also financial abuse. And very, very, very frequent occurrence. And that's a red flag not to go to mediation, because you need an advocate. You need someone to stand in front of you and say, this is acceptable, that's not acceptable, and we need more information to make an informed decision.
We know what traditional litigation is. Two people hire two lawyers. The lawyers go through a whole discovery process. And then in the end, either they end up in trial, which is pretty rare still nowadays. More likely, they're going to end up still in mediation with an attorney mediator who is going to keep them there until basically they settle. Now, I know you're also very involved in the collaborative divorce movement. Explain to our listeners what a collaborative divorce is.
I just want to tag on to what you're saying in terms of the litigation. I would say probably 98% of cases settle without going to trial. So my question for so many people is, why would you start engaging in litigation and not really from the outset have a negotiation mindset? Because you're not going to trial anyway. But, you know, also having said that, there are cases that absolutely have to go to litigation. Lack of transparency, financial abuse, evaluate where you really, really can't agree on issues and you need the court to decide. But that should really be your last recourse. So I got into collaborative divorce because I was looking for options to traditional divorce litigation. And it's kind of in between mediation and litigation, because in collaborative divorce, each person is represented by their own collaboratively trained divorce attorneys. So we're divorce attorneys. We're still advocates. We still represent our clients. But we look at resolution in a different way. Instead of fighting against each other to argue our case and win, the first thing we do is we try and understand what are each of our respective clients' goals and interests. What does he want? What does she want in terms of everything? And then we try and get to, it might not be a win-win, but it's like the story of the orange. You probably know the story of the orange. There are two people fighting over the orange. He wants the orange. No, she really wants the orange. And then when I ask her, well, why do you really want the orange? And she says, I love orange juice in the morning. It's so refreshing. And he says, oh, I love to make orange cake. The rind of the orange is so delicious. So we come to discover that they both could have the orange. And that's really what collaborative is about. It's really about problem solving and digging deep and coming up with options with a team of professionals who could really help these people sort out what their differences are in a way that makes sense. And it's not, excuse the expression, a shit show. It's very targeted and it's very direct. And they get to make the decisions.
So who would you say the collaborative process is not a good fit for?
Well, I think it's probably not a good fit for someone who has a very simple case. W-2 employee, just a really, really simple case. It's also not a good fit for someone who is not willing to be transparent because it's a collaborative process, it's a non-court process. And the beauty of that is that none of your financials or your private information is in the court record, right? I mean, if people get divorced in the state of Florida, they could go and your friends and your colleagues or potential, employers can go and search your file and look to see what happens and look to see what your finances are, look to see where your kids go to school. But this could all be private and kept out of the court system. The issue, though, is if someone is not going to be transparent, we have no ability to compel that person to produce the documents. So if you know that one of the people is trying to get over the other person, really screw the other person, lie and not be transparent, it's not suitable. That case is not suitable for collaborative.
Also, in my experience, where collaborative can sometimes fail is when someone is demanding something so unreasonable and unrealistic, and they, because of their own mental health, will not be a little more realistic. It's a poor choice because in the end, it seems to me that the spouse who is the reasonable spouse who just wants to move forward, in the end, they often bite off their own foot just to free themselves from the marriage and not have to go back and start all over again with traditional attorneys.
So I agree to a certain extent. I've had cases where people have been, it's divorce. People get unreasonable. They really do get emotionally loaded and flooded. But if you have a good team, it's really important. And I've had cases where people have been extremely unreasonable and we came to settlement because we come up with so many options. There's not a bad option. There's not a good option. There are just options. In my office, I settle 97% of my collaborative cases.
The final process that I want to talk about, of course, is the one that I provide, which we call pro se pre-suit divorce. So a couple wants to get a divorce. They come into our office. We take them through a series of questions. They negotiate the answers to the questions, and we prepare the agreement, the parenting plan, and all the documents that they need. But one place that sometimes our process lacks is one or both spouses wants to have the agreement reviewed by an attorney before they sign. And I know that that is something that you're willing to do. Can you talk about that?
So it's a legal term. It's called unbundled service. Everything is changing. What my desire is to change the culture of divorce. There's just not one way to divorce. So you could combine a couple of different things. So they're going to come to see you. You're facilitating the conversation. You're not necessarily giving them legal advice. There's the agreement. Well, very often we see that, the agreements are only as doable and durable as they're written. They have to be well-written agreements. And sometimes another set of eyes is very helpful, especially a lawyer's eyes. So there are lawyers we call consulting attorneys. Now, their role is not to recreate everything, is to take the deal that's on the table. The client's coming and saying, this is really what I want. I'm really, really good with this, but could you look at the agreement and make sure that it's legally sufficient, that it is an enforceable agreement, that I won't have to end up in court, and that what I want and what is reflected in this agreement is actually realistic legally and will be effectuated. And that's really what we are. We're consulting attorneys. And very often, I'm a mediator as well. I have a list of consulting attorneys. So I know that these attorneys are not going to shake up the whole thing and screw up the whole thing and be shit stirrers in the whole process. They're going to do exactly what I said. They're going to review it and make sure that it's in the client's best interest and it's an enforceable, durable agreement.
So this is actually my 35th year in the mediation. I don't know if I can call it a business, but it's my 35th year as a mediator. So it's sort of amazing to me that this has been my lifelong career. So Mara, I want to thank you for joining me on the maiden voyage back to the Divorce Depot. And we will continue to try to help people as best we can, both of us, to do good works in the world and make the divorce process, which is really a wonderful chance for many people to have a do-over at a life that isn't working for them. So we'll continue to do our good work, I guess, until it's time for us not to do it anymore. But for now, we're full speed ahead. Thank you. Thank you, Mara.